Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 77th lecture series. We always recite the preamble of the Constitution of India before we go on to the topic. Because reason is preamble, the reflection of the entire Constitution provisions. The goal is enshrined in the preamble of the Constitution of India. So preamble, that is our unity and that is our dignity. Preamble reflects our commitment, sentiment. Preamble our goal, preamble our soul. Therefore, I request each one of you to recite preamble along with me, dear friends. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. We are going to discuss about Article 370 of the Constitution, abrogation of Article 370. This is also one of the leading cases in the Advocate on Record examination. Just now we have completed 76th lecture by studying the entire overview of the judgment. Let us keep 76th lecture as a guiding light. Let us keep the message given by Swami Vivekananda ji also. Reason is, education without values is useless. Education with virtues, education with values, it is really going to help others. So with the help of Swamiji, with the help of that lecture 76, let us approach. I will be taking you to the relevant portions, relevant paragraphs, page numbers, because it is running to several pages, dear friends. So please take note of every paragraphs, that will be helpful to you. It is reported in 2024, 11 Supreme Court cases, page number 1. The name of the case is Article 370 of the Constitution in re. Let me take directly to page 89. This is reported, therefore you can refer to those pages. Page number 89. At page 86, the judgments of the court were delivered by my Lord Dr. D.Y. Chandrachud, Chief Justice, for himself, for Justice Honorable Justice Gavai, Honorable Justice Suryakant ji, Honorable Justice my Lord Justice Cole and Justice Khanna. They were concurring with their own opinions. So it's a unanimous judgment. Let us confirm ourselves. It is a unanimous judgment. And 2 pages table of contents given by Honorable Supreme Court, and it is written over there. Please go through those contents, running to 2 to 3 pages. Table of contents from page number 86, 87, 88 and 89. The entire 200 pages, what is being discussed, it is given in these 4 pages. You can look at the table of contents. That will give you a brief idea about the subject matter. Now let me take you to page number 89, paragraph number 1. What is the challenge? Page 89, paragraph number 1. Rather it is paragraph number 2, but I want to read from paragraph number 1. This judgment, these are the opening lines. This judgment is enriched by the discussions with my distinguished colleagues Sanjay Kishan Kaul, Sanjeev Khanna, Bhushan R. Gavai, Surya Khan, justices, during the course of oral arguments and thereafter. Their inputs to the judgment have led to a synthesis of thought resulting in a unanimous outcome. So, because of the discussion during the course of the argument, even after the arguments are also over, when they discuss together, they can reach a conclusion, a unanimous judgment. We record, Supreme Court, Honorable Supreme Court is recording our deep appreciation for the scholarship of the senior counsel during the course of arguments and in the written briefs, assisted by an able team of junior counsel. So recognizing the, not only the senior but also the junior. The good judgment comes from the good arguments. So it is our hard work, it is our means. The product is the judgment. Means is this, we are supplying the arguments. Based on that, judgment is delivered. So this is the opening lines. Let us enjoy, dear friends. We should enjoy. Paragraph number 2. Article 370 of the Constitution of India incorporated special arrangements for the governance of the state of Jammu and Kashmir. There is a special status given to the state of Jammu and Kashmir. The President issued constitutional orders 272 and 273 during the subsistence of a proclamation under Article 356, Clause 1b. That means during state emergency, during President's rule in the state of Jammu and Kashmir, President has issued two constitutional orders, 272 and 273. These orders, what is the effect of this order? These orders have the effect of applying the entire Constitution of India to the state of Jammu and Kashmir and abrogating 370, abrogating Article 370. Contemporaneously, the Parliament enacted the Jammu and Kashmir Reorganization Act 2019, which bifurcated the state into two union territories. So finally, the petitioners have challenged the constitutionality of these actions. So these are the challenges, dear friends. Now let me take you to page 92. Reference. When the matter came up before a 5 judges bench, the council made the submission that it should be referred to the larger bench above 5 judges. The court asked why? Why should be referred to more than 5 judges? Tell us. The answer now they are giving. Whether that answer is accepted or not, let us see. On 19th August 2019, the jurisdiction of this court was invoked under Article 32 of the Constitution in Soy Faisal versus Union of India. So they filed a batch of petitions challenging the constitutional validity of constitutional orders 272 and 273, came before a constitution bench. The petitioners sought a reference to a larger bench. Why? The submission is that they refer to one leading case, constitution bench judgment, that is Prem Nath Kaul versus state of Jammu and Kashmir. Prem Nath Kaul versus state of Jammu and Kashmir, that is reported in 1959, supplementary to SCR 270, page number 270. 1959, dear friends. In this case, what happened? A constitution bench held that Article 370 was temporary in nature. Article 370 was temporary in nature, held in Prem Nath Kaul case. But according to the council, petitioners council, subsequently in Sampath Prakash versus state of Jammu and Kashmir, this is 1969 to SCR, after almost 10 years. With respect to the reporting, 1959 Premnath Kaul, 1969 Sampath Prakash versus state of Jammu and Kashmir. In this case, what happened? Another constitution bench held, without considering the decision in Premnath Kaul, that Article 370 is not a temporary provision. They are giving the reasons why it is not a temporary provision. So Premnath Kaul says Article 370 is a temporary provision, but Sampath Prakash says it is not a temporary provision, meaning thereby it is a permanent provision. Therefore, two constitution bench judgment contradicting to each other, and it is decided by 5 judges bench. Therefore, it should be referred to the larger bench. This is the crux. But ultimately, the Honorable Supreme Court denied to refer to the larger bench. Why? The answer given by the Honorable Supreme Court is, you cannot pick up a particular word and then blow it. It should be read with the context. Therefore, according to us, the reference is not required to larger bench. That is what they have held. Let us see the reasons. I am reading para 16, dear friends. The Constitution bench, while rejecting the plea for a reference to a larger bench, adduced 3 reasons. I'll take you to the main reasons only, which emerge from the extract of the judgment set out below. First, it is worth highlighting that judgments cannot be interpreted in a vacuum. Dear friends, what they have given is how to interpret a judgment. Already leading cases are there, but if you want to take the help of the judgment to your facts of the case, how will you take that judgment? How do you make that particular judgment as a precedent, and how do you seek the support to your particular case where you are appearing in a court of law? They are saying, first, it is worth highlighting that judgments cannot be interpreted in a vacuum, separate from their facts and context. So whenever you are reading a judgment, what is the background of the case? What is the context involved? Why they have used, in what context they have used? That is most important. When somebody look at our video by saying that Swamiji has been invited, they will wonder. But if they listen to our entire video, the spirit of great souls never dies. They are always living with us. That is the belief that we carry, because they are guiding throughout us. Those spiritual leaders are guiding our nation also. This country is called as path of spirituality, the land of spirituality. That is how we have been identified by foreigners. They say, if they visit some other countries, they say we are going for trip. But when they come to India, they say we are on the pilgrimage. We are on pilgrimage, visiting Kashi, visiting Rameshwaram, Meenakshi temple, Lord Venkateshwara, and many other, Puri. So many places, holy pilgrimage. The entire India is known for its spirituality. We are the masters of the spirituality. And the entire world listens to India for spiritualism. So therefore, dear friends, let us not lose the essence. So, observations made in a judgment cannot be selectively picked in order to give them a particular meaning. The court in Premnath Kaul case had to determine the legislative competence of the Yuvaraj in passing a particular enactment. The enactment was passed during the interregnum period before the formulation of the Constitution of the state of Jammu and Kashmir, but after coming into force the Constitution of India. The observations made by the Constitution bench in this case regarding the importance given to the decision of the Constituent Assembly of the state of Jammu and Kashmir need to be read in light of those facts. So you cannot just pick it up and then say it is contradictory. You have to read it from the context. And ultimately, the Honorable Supreme Court has held this court sees no reason to read into Premnath Cole case an interpretation which results in it being in conflict with the subsequent judgments of this court, particularly when an ordinary reading of the judgment does not result in such an interpretation. Don't see it from the petitioner's view, see it in a plain language. When there is no conflict, we will not refer to the larger bench. Therefore, the Honorable Supreme Court decided the entire case by 5 judges only, and they refused, they denied the prayer of the petitioners from referring to the larger bench. So these are the issues, dear friends. Now, in the upcoming session, we will discuss about what are the issues involved and what are the conclusions given by the Honorable Supreme Court. So thank you so much, dear friends, for your patience hearing.